we saw that, yesterday, it's called, it ends with this.
¿Cómo le hago para que no me vean aquí?
Everybody hear me loud and clear? Can everybody hear me loud and clear?
Yes.
Okay, great. So we're going to talk about the changes that have taken place as of yesterday. And technically, the settlement agreement is not, as you know, signed yet by the court till November 26th, the date set for the judge to sign the NAR settlement. But we're implementing the provisions effective the 13th, which was yesterday. And the rest of the settlement provisions get implemented on Saturday, which will be the 17th. So those are the two deadlines this month. So effectively, as of yesterday, we do business slightly different than we did before. Now, I hear a lot of comments in the industry, the sky's falling, it's a different world, and everybody's panicking. But I'll tell you, in the big picture and scheme of things, the changes that we're doing and the changes that we're required to do are relatively simple, straightforward. And so if we just keep it simple and not get bogged down with all of the ridiculous comments and rules by all the new ridiculous forms that we've been provided, and just concentrate on the forms that we need to comply with CRMLS rules, I think we'll have an easier ride with all of these transitions. So I'm going to talk in three categories today. The first category is it corresponds with the first of the three newsletters that I sent over to RE/MAX yesterday. The first newsletter was new listings after August 17th. Well, now technically August 13th. And there's a couple of highlights in there that are kind of important to reference. And we did talk about this briefly during the very last in-person meeting that we did. And I start out with a couple of sound bites that I found online. One of them was, major settlement spells end of commission in California. That's one thing that we found on the news feed. Another one was realtors agree to end commission in California, right? That's another thing I've read. 6% commissions gone forever in California. That's another one. And the fourth one I read this morning was seller paid commissions are over. Well, the reason I bring these sound bites to your attention is that's what your sellers and buyers are reading. That's what they're reading online. This is their perception, is that whatever happened means they don't have to pay anybody any longer, which is not what happened. So the reason I bring the sound bites to your attention is the very first order of business for you as a listing agent is to be prepared with a response to these sound bites. And so they're very simple. I have like a 3 or 4 step four-step process that you should think about, so that when you go into a new listing, you know in advance that as soon as the seller brings up, oh, I heard that we don't have to pay commissions any longer, you have a canned response that's ready to go.
And then they'll be like, wow, she's like really into me.
Champions, can you guys make sure that you guys are all muted so that Rod can speak? And if you have questions towards the end, you can unmute. Thank you.
Okay, we're ready to go. Okay, so we're going to continue. So basically what you need to do is, as soon as your client brings up that point, hey, I heard that I don't have to pay commissions to you or to the buyer's broker any longer, then you should have something that's ready to respond with. Like say, oh, first of all, that was a settlement that related to a case in Missouri, has nothing to do with California law, which is true. Number 2, the case was never reduced to a judgment, which is also true. It was settled. So it's not a judgment. Number 3, the settlement only resulted in new disclosures and forms. And that's your first response that you should be ready to spill out immediately to your client, so that they understand they're still required to pay commission. Okay. And then the next thing they're going to want to challenge is your right to offer commissions to the selling office, to the buyer's broker. And you need to have a canned response there too. And it needs to be exactly the same. As soon as they say, well, I don't think I have to pay the buyer's broker, I read that somewhere, then you can say, look, you don't have to pay anybody. But if you don't pay anybody, nobody's going to see your property. So if you want to sell your house, nothing's changed here. And the importance of offering compensation to the selling office is just as critical today as it was yesterday. So make your best canned response, have it ready to go, because your new sellers know, because they've read the same sound bites that I started the lecture with, and they think that they know something was up. And the something that's up is that they believe that they don't have to pay commission any longer. So for you to get the upper hand on that argument and dispense with it right away, have a canned response ready to go. Once you have that ready to go and you snap it back to everything they say regarding the commissions and their obligation to pay it, and then as to offering compensation to the selling office, you have that canned response. My experience has been with the agents that have had that ready to go, the sellers behave exactly as they did last month. They say, oh yeah, I understand that. So then they sign the commission at 6% or 5% or 4.5% or whatever you negotiated. And then they authorize you to offer compensation to the selling office, just like we did last month. Nothing changes, but you have to have your canned response ready to go. That's the first newsletter that I sent out of 3. And it just addresses an issue that I've already seen come up many times in the last, like say, 2 or 3 months. One in particular is an office that I represent down in Dana Point. And they had a listing on a difficult property to sell. The property finally got a full price offer about 3-4 weeks ago. And the listing agent went to the seller and says, I got a full price offer on this property, and thought the seller would be ecstatic with that information. It'd been on the market for 6 months, very difficult property to sell. And the seller said, oh, that's great. And I just read that I don't have to pay anybody commission. So as soon as you revise the agreement to state that I don't owe you or the selling side commission, I'll sign the full price offer. And so again, these are the kinds of comments that we're hearing from sellers. And so you need to be prepared and have a canned response to respond to each and every one of them with kind of the same flavor of answer. So there's in that particular case, the listing agent already had this lecture. And so the listing agent said, oh, that's a settlement. That's a case that results from a Missouri jury. It has nothing to do with California. It was never reduced to a judgment. And the changes that are made only relate to forms of disclosures, which we have to do, which have nothing to do with commissions at all. Commissions are still negotiable, but they're an important part of the process here. They're not illegal. And then with respect to listing agent, selling agent side, same thing. Nothing's changed. If you want to sell your property, you have to offer commission to the other broker, or they're not going to show it. It's flat out simple. So if you want to sell it, we got to keep the structure exactly the same. And the seller in that case said, oh, I understand that. Sign the offer, the deal closed, everybody got paid. So just remember, you got to have canned responses when you meet your sellers to address all of these sound bites, and then also address that there's still critical importance to offering cooperative compensation to the selling office. Number 2, the next two bullet point lectures are going to be based on buyers and sellers. The first one is representing sellers after the change. The second one will be representing buyers after the change. because there's new rules that have been imposed by NAR. These are not California rules, by the way. These are not statewide rules. These are rules that are imposed by NAR and CRMLS that change the way that we do things as representatives of the seller and representatives of the buyer. So we're going to talk about the seller first. Now we've got a new RLA. We've all looked at it. Some of you may have used it. There are really only 4 paragraphs that are critical for you to read and understand on the new RLA. And by the way, the new RLA, the new listing contract, I think is actually a better agreement than we had before. So that's the only positive thing I'm going to say about CAR, is that this particular agreement is generally better in terms of format than the last one, because it's more consistent with the RPA, where all the material provisions that you fill out are on the first page. Same thing. So it's a great format, but we do need to understand that there's 4 paragraphs that you need to be really critical of that you haven't seen before. It's 2C1, 2C2, 2C3, and 2C4. 2C1 through 4 on the very first page. That's where the beef is. That's where everything occurs on your listing contract that makes any difference with respect to your right to commission. 2C1 is a straightforward listing amount paid to you. So if it's a 3% listing to you, you're getting 3% regardless of whether it's a dual, whether it's whatever happens, then that's the amount that goes to you. That goes in 2C1. That's your commission as a listing office, as a listing broker. That's 2C1. 2C2, that's a weird provision. Originally, I thought that was intended to be used in a dual agency. But if you read the paragraphs that define 2C1, it's kind of an ambiguous paragraph. So in light of what I'm going to tell you in the future, when you complete your RLA, I don't think I would put anything in 2C2. Because that involves a situation where you represent the seller and the buyer is not represented by anybody. Well, I mean, reality is you're probably in that case going to be a dual agent, in which case the other provisions I'm going to talk about in a few minutes will apply to your listing. So C21, that's the commission you're going to get. That's your 3% hypothetically. 2C2, I would not fill it out at all. 2C3, this is the same as the provision for continuing commission in the original RLA. This, if you fill that in, remember, it's 90, 120, or 180 days. Doesn't matter which one you choose, but that just gives you a right to commission if they close a deal with one of your prospects after the listing expires or is canceled. So that's all 2C3 is. It's exactly the same in theory as the original RLA that we have. And 2C4 is just identification of a previous broker. If your seller says, I have a previous broker and I owe them something, well, that provides you a place where that can be inserted so that if the previous brokers owe commission, if they sell to one of 3 people who are prospective buyers, that can be included directly onto the RLA and 2C3, 2C4. So in a nutshell, what am I talking about? 2C1's your commission at 3%. 2C2, I'd leave it blank because it's unintelligible. 2C3, that's the number of days after expiration that you're going to get paid if they close a deal with somebody you brought to the table. And 2C4 is just simply the previous broker. If they have an arrangement with one, they can put it there. So that's the basic RLA. Now, we've left out a very huge, enormous part of the RLA, and that's cooperative compensation. And so we're going to address cooperative compensation differently. There's 3 ways we can do it. And this is really critical because you're going to want to have the opportunity to offer cooperative compensation on your own websites, your own flyers, and during your own phone calls, emails with people bringing buyers to your properties. And you're going to have that authorization, and it's going to have to be spelled out and agreed to. There's 3 ways we can do it. I'll tell you the 3 ways, and then I'm going to recommend the one that we use. First of all, you can go straight to paragraph 2K of the RLA. It says additional provisions or additional terms. You can write in there the cooperative compensation that's all that the seller allows you to offer. Now, how does that read? I have very specific language that I'd like you to consider using. And it's in my newsletter, and it's repeated 3 times. I'm going to read it one time, just for those of you that don't have the newsletter. This is sort of the language I'd like you to use. Seller authorizes and instructs broker to offer 3% of the sale price as cooperative compensation to any broker who produces a buyer. Total commission paid by the seller would then be 6%, with 3% paid to the listing under 2C1 and 3% paid to the broker who brings a buyer. So the language accomplishes two requirements that are necessary under the NAR settlement. One is it specifically authorizes independent commission to the selling office that's approved by your client. Two, it specifies the total amount of commission due to you and to them combined. So there's two sentences, and that's what each of them do. That language is exactly the same, regardless of how you include cooperative compensation in your RLA. So the first place you can do it is you can put that language into K. You can do that if you want. And that way the agreement is all in one agreement. Now, I don't like that. That's not my preferred way for you to do this. You can do it. The reason I say it's not preferred is it's buried on the second page. And I can very easily see that a seller might try to confuse that as saying it wasn't adequately disclosed and then try to get out of paying cooperative commission or blame you for it. So 2K, possible, you can do it. It's legal, it's authorized. I don't endorse it. You can put it in a new form called modification of terms of listing agreement, MT-LA. Now, this agreement I get excited about because this agreement is the one where I think this language about cooperative compensation belongs. The cooperative compensation, the exact same language that I just read to you, that's in the newsletter that relates to representing sellers after August 17th, 24, will go right in the modification of terms / listing agreement. And it's a one-page freestanding modification that would be underneath your RLA. So you basically have two documents, RLA, which says the commission you get, and the modification of terms / listing, which are the terms that you're authorized to offer to the selling office. That's the way you should probably do it. That makes the most sense. It's going to be hard for your seller to say, I was confused about it. I didn't know that it was there, because it's a one-page document that your seller independently signs. That's a modification of the RLA. It's a form they created, I think, for this purpose. Third way you can do it, and this is equally as effective, is an addendum form. So you can just use an addendum form, addendum to RLA, and put the same language regarding cooperative compensation as I read at the start of the meeting. Okay, so in summary, that's all there is. I mean, when you're talking about taking a listing, that's all there really is in terms of changes that you must do in order to comply with the current rules under NAR. There's a lot of other forms that have been created. There's a lot of scuttle in the industry about things that you should be doing or maybe recommending you do. This, I keep it very simple to this format for the time being, so we can keep business exactly like it is, like it was, like it is, and like it should be. With you as a listing agent having authorization to offer cooperative compensation to the selling office. Simple, easy, nothing more, nothing less. That's all there is to representing a seller that's required for you to secure commissions. All right, so now let's go on to representing buyers after August 17th. This is a little more complicated. And just a little bit of background, it was in the 1990s when a group of lawyers originally complained that the buyers were not getting a fair shake in real estate transactions because they didn't have money to pay commission. And so at that point in time, NAR and CAR and all the other organizations modified the way they did business and came up with what we called the cooperative compensation model. And that's the model by which all of the commission came from seller's proceeds for the buyer's agent and the seller's agent. And that's what we've done for the last 30 years. And that was the result of lawyers complaining that buyers weren't getting a fair shake because they didn't have the money to pay for their own broker. And that's why they thought that was a good idea. The same consumer advocate lawyers now came back to make $1 billion and said, hey, we don't think that's fair to the sellers now. And so now the buyers are kind of left to their own accord. That's how we got to this place. So it's unfortunate, but we've got several ways around the problems. So let's talk about it for a minute. In a perfect world, NAR and CRMLS want you to have two things in your file when you meet a new buyer before you give them information about a property or show, tour, or inspect any property with them. The one is they want to have a signed agency disclosure right up front before you have any discussion with the buyer concerning a property, providing them information, property profiles, or viewing or showing the property to them. They want an agency disclosure. California law says agency disclosure as soon as practical, but in no event after the offer is formed. But California law is ignored for purposes of what NAR wants us to do. If you're an NAR, CAR, if you're a realtor, you have to follow these rules that they prescribe. Their rule is you need an agency disclosure signed. The second one is you need some sort of a broker compensation agreement signed before you ever show your buyer a property. That's a big problem because my experience has been that buyers, when they walk in or they first contact you and you say, okay, I'm more than happy to give you property information. I'm more than happy to show you a property, but you got to sign this agency disclosure, which is 2 pages. And then you got to sign this other broker compensation agreement, which is 5 pages, single spaced, to pay me money if I find you a property. And my view is no buyer is going to sign that thing when you first meet them. You're never going to have the opportunity to build a relationship with the client because a good percentage are going to bolt when they're presented with that form to sign. And you're never going to get an at-bat with that client. You're going to miss a lot of at-bats. So I've created a smaller form. It's a 1-page broker compensation agreement that I think your clients will have an easier time digesting. It's 1 page, and it basically says they owe you nothing for showing a property. So basically what we're doing is when you show a property today, they owe you nothing. And when they sign this agreement, they owe you nothing. So it's basically an agreement created strictly to comply with the NAR settlement. And it basically keeps business exactly like it is today, where you can just say, hey, here's an agency disclosure and a 1-page large print buyer compensation agreement that confirms you don't owe me anything for showing property. So we'll build the relationship, and the buyer broker agreement comes later, and we'll talk about that. The one that actually has compensation in it. So there's another thing you should be aware of with respect to why I created this form. Some of the agents that I represent said, well, I'm just going to have them sign the agency and I'm going to ignore the buyer broker and just do exactly what I've been doing for the last 20 years and show the buyers the property, give them information, build the relationship, and then I'll get them to sign a buyer broker agreement before we do the offer. And that's fine, except CRMLS revised Rule 9.1. And you may not be aware of it, but it's happened about 2 to 3 weeks ago. So they revised Rule 9.1, and basically what they revised it to say is that they will fine you $2,500 if they become aware that you were showing property without some type of a buyer broker agreement signed. So they made it an administrative violation where they can fine you immediately $2,500 with no notice if they get wind that you were showing properties and didn't have a buyer broker agreement. So that's what caused me then to go to the drawing board and draft this 1-page buyer broker agreement. I did that specifically to comply with Rule 9.1 to allow you to continue to show properties and provide information with the same ease that you do it today, kicking down the road the formal buyer broker agreement until the offer is presented. So that's why I did that. Now let's talk about the offer. Let's say you did everything I told you to. Client walked in the door. You said, oh, here's an agency disclosure. Here's some property information. Here's a 1-page agreement, buyer broker agreement, says you owe me nothing. They sign it. Then you've showed the properties to clients, and your client as a buyer says, I want to make an offer on 123 Snuffleupagus Street. And you say, excellent. Now there's a trilogy of documents. And that's a great word to use because there's really 3 documents you need in every offer from this point forward under my proposal. It's a trilogy of documents. It has to be done in a very specific order. And then we'll talk about each document. The 3 documents are the formal buyer broker agreement, BRBC. So it's buyer representation and broker compensation agreement. That's the first document in the trilogy that has to be signed and negotiated. That's the document that you now can complete with the property address of the one that you're making an offer on. And you can actually properly put in the amount of commission that the listing office has told you or advertised that they're offering. Because now you're prepared to write an offer, and you either would have discovered the amount of commission they're offering you, or you would have read about it, or you would have called the listing agents. And if I bring a buyer, what are you offering as compensation? So you have a buyer broker agreement first that contains the commission that's been confirmed that they're offering you and the property address. Now, document number 2, same time, you're going to prepare the RPA. Standard RPA, only difference being you're going to check box 3G3. Because box 3G3 is what entitles you to commission on the offer that you're writing. So far, you've got 3 documents lined up for your client to sign, or you sent them 3 documents in line to sign. The RBC, the RPA, with special attention to box 3G3, which is your commission box. And the third document is the seller payment to buyer's broker form. It's a 1-page form, poorly drafted as it can get, but it's the only one we have, and so we're going to live with it. So those are the trilogy of documents that you need to have on every offer from yesterday forward. So if you represent a buyer,
please repeat that last one.
Yep, it's going to be repeated many times. You will be sick of me talking about it. But yes, the trilogy of documents, BRBC, which is the buyer representation and broker compensation agreement. Number 2, the actual offer itself, residential purchase agreement. Special attention to the commission box, which is 3G3. I call it the commission box because that's what entitles you to commission once you engage it. Then the seller's payment to buyer's broker. That's SPBB. You need to be very familiar with that form. And we're going to discuss it in detail in a couple of minutes here. So let's talk about the residential purchase agreement, just to kind of recap. On the residential, I'm sorry, let's talk about the buyer's representation and broker compensation agreement, BRBC. Then we're going to talk about the residential purchase agreement. Then we're going to talk about the seller payment to buyer's broker. The 3 initials you need for the identification of the forms. Document 1 in the trilogy is BRBC. Document 2 in the trilogy is RPA. And document 3 in the trilogy is SPBB. Okay, so the BRBC, there's only 4 paragraphs that become really critical for you. And if you do nothing else, do these 4 paragraphs. A1 is the representation period. The agreement defaults to a 3-month term. I would leave that blank. I would not put I would not put anything other than a beginning, would not put an ending date. I would just rely on the 3-month expiration. So that's what I would do with A1. A2, type of representation. At this point, you're going to check the box so that you represent the buyer exclusively. So A2 allows you to then be an exclusive agent, which is important now that you're making the offer concurrently with this form. Number 3 is B1, type of property. You need to put the address in order to queue it to the RPA. And then E1, the amount of compensation. This should be the percentage of commission that the listing agent offered you, either online or during conversations confirmed in an email as to what they would pay you if you submit an offer that's accepted by the seller. So that's what E1 would do. So again, A1, start date only, form lasts 3 months. A2, type of representation, exclusive to the buyer. B1, property type, property address. E1, amount of compensation, that's the cooperative compensation that the listing agent offered to you. If the listing agent didn't offer you anything, or you haven't had a discussion with them, then you're going to plug in whatever's 3%, whatever standard. You can do 2, 3, or 4%. It's up to you, but it has to match the RPA if you had no discussion with the seller or the listing agent. Document number 2, the RPA. Comments are even simpler. The only paragraph that really changes for you in the RPA is that you're now going to use 3G3 with every offer. That's the box that simply says, and I'll read it because it's 1 sentence. Seller agrees to pay the obligations of buyer to compensate buyer's broker under a separate agreement, CAR form SPBB attached. So all that does, that's the commission paragraph. 3G3 is the only new provision that you really need to be concerned about in the short haul. So we've gone through, just to recap before we get to SPBB. First document in the trilogy is the Buyer Representation and Broker Compensation Agreement, BRBC. In that, you must have A1, A2, B1, and E1. Those are the critical paragraphs that need to be completed. Then you have the RPA, Residential Purchase Agreement, Commission Paragraph 3G3. That's the key for you to assure yourself payment of commission. Now the third document in the trilogy is Seller Payment to Buyer's Broker. CAR put this form out about 2 years ago. And the only reason we used it then was for sale by owner properties, because that's the only way you would get commission is to use 3G3 and then include SPBB, and then have the seller sign it on a for sale by owner who was not represented. That's the only time we really use that form. But now it's going to be used in every single offer from yesterday forward until these documents are revised, in which case we'll talk about it then. So this is a very simple one-page agreement. There's 3 paragraphs that you need to be concerned about. Paragraph 1, paragraph 2, paragraph 3. Simple as that. Paragraph 1 is basically, this is the percentage of commission. It's called Buyer's Representation Agreement with Compensation. This is the same percentage commission that you plugged into your BRBC. So if your BRBC says that your buyer agrees to pay you 3%, then the SPBB on paragraph 1 has 3%. That's exactly what the buyer agreed to pay you. And that's what you're going to ask the seller to pay. Paragraph 2. Now, this is kind of a tricky paragraph. So I'll tell you kind of what we think happens here. So it's called compensation from seller's broker to buyer's broker. This paragraph is used when the listing agent made an offer of cooperative compensation to you, either in writing by email or in flyers or in a broker-owned website, wherever they're offering commission. If the listing agent told you 3% is what the listing site is offering as cooperative compensation, then you would use paragraph 2, and 3% would be the amount the listing agent offers you, and you're done. That's the end of the agreement. Here's the other scenario. This is where paragraph 3 comes in. Let's say that you can't get a hold of the listing agent, so you don't know what they're offering. Let's say that you called the listing agent and the listing agent said that her seller is offering no cooperative compensation to the selling office. So basically you're saying, well, the listing agent hasn't really offered you anything. So you don't have any commitment for commission. In that case, you go straight down to paragraph 3, and that's where you're asking the seller to pay it. So it's either 2 or 3, but not both. So if the listing agent tells you what the commission is that they're offering, then you complete paragraph 2. If the listing agent doesn't tell you, then you go straight to paragraph 3 and you put 3% or whatever you're asking the seller to pay. So that's the only trick in filling out SPBB, is that after you get past paragraph 1, which is the amount that your buyer is going to pay under BRBC, if the listing agent tells you the percentage, it's going to be in paragraph 2. If you don't have a commitment from the listing agent, you're going to ask the seller to pay it in paragraph 3. Nothing more, nothing less. It's really that simple. It can be a lot more complicated if you want, but that's really as simple as it is. Just remember, when you're representing a buyer, that's where you're going to have more work to do. That's where you have to remember you have a trilogy of documents that need to be completed, and you need to complete them. Be very simple with them. Don't get tied up with them. Just go back to my checklist and remember, there's really only 4 things you need to be concerned about on the buyer representation and broker compensation. There's really only 1 paragraph you need to be concerned about on the RPA that's different than what you've seen in the past. And there's really only 3 paragraphs on the SPBB that you need to include. If you make the mistake of submitting an offer without having an executed BRBC, under the new rule, you forfeit your right to any commission. So you can't have your buyer sign the BRBC after the offer. It's too late. It has to be the document that's signed first in the trilogy. If the buyer signs it afterwards and the offer is outstanding, seller has no obligation to pay any commission at all to you representing the buyer. So BRBC 1, RPA 2, SPBB 3. Again, that's all there is to it at the end of the day. I hate to make it this simple because I know that there's been a lot of guys out there making this really complicated, but it really is not a big deal. Now I'll take questions at this point. We've got 10:40, so we've got maybe 10, 15 minutes of questions.
I have a quick question,
Yes.
Leo. So can I tell my buyer if they're not offering commission, we're not going to go look at the property and be totally open with them?
Yeah, you can say you're not willing to sign, you're not willing to show it if they're not offering anything. They can see it if they want, but you're not going to. Well, why would you spend your time if they're offering nothing?
Correct.
Otherwise, you're more likely to work for free. Or you can say, look, one of two things. They're not offering commission, and you can say, I have one of two things. You can either see the property yourself, or we can enter into the BRBC now, and you can pay me X number of dollars if I represent you in the transaction. So you have two options. It's not just an all or nothing. There's more than one option. So you have a listing agent says, I'm not paying, my client's not paying anybody anything. We're not paying the selling office a penny. Then you'd go back to your client. I would disclose it. The selling office offers no commission. You're more than welcome to see it and make, represent yourself in the deal, or I'll represent you subject to terms of a BRBC where you get paid $10,000, $5,000, $2,500, whatever you negotiate with them, but that'll come then from the buyer.
Okay.
It works if you're a wealthy buyer, because if
Yeah,
you're
I know.
a buyer and you're going to take 10,000 from them, they're not going to qualify for the house any longer.
Right.
That was the problem in 1990 that resulted in the cooperative compensation model in the first place.
Right. So
Now,
what about this? This includes rentals too, right? If we're going to show rentals, or same thing, it's all the same.
it looks like it. There's a separate agreement for rentals. So you don't use these documents, but there is a separate property agreement that applies. Like, for example, there's a separate showing document for rentals. So they create a whole group of documents that you use for rental properties.
Now, Rod's form kind of replaces the BRBC, but not totally. Is that how it works?
Yeah, excellent. I'm glad you brought that up. You're going to, in every single transaction file, you're going to have an agency disclosure. You're going to have my form, which complies with Rule 9.1, so you don't get fined. It's the only reason it exists. That says no commission. So you're going to show properties with no expectation of getting a penny. Your only expectation is once you find a property, then you'll do the BRBC, the RPA, and the SPBB. That's when you set forth your right to commission in the BRBC for the first time. That's when it's negotiated. And that makes a lot more sense, because my theory is by that time you would have gained the client's trust. And then you explain to them, here's my broker compensation agreement, but you're not paying me. We're asking them to pay it, and they're going to be more apt to sign it. And it's going to be very specific to one property, the one you're making an offer on. So that logic makes a lot more sense to me. And I don't think you're going to get a lot of resistance from buyers. If you show the buyer right off the bat that 5-page BRBC, which hopefully you've looked at it, you'll realize there's no way in the world any buyer is going to sign that thing. They're just not going to do it. Nobody that walks in off the street will sign that form that they've created.
Awesome. Thank you.
My pleasure. Any questions you guys have? I know there's a lot going on, but I reduced
I have a
it
question, Rod.
as simple as it can be. Yes.
If I have an active listing, not currently in escrow, would we use the MTLA, the modified terms for the listing agreement, to confirm that the seller is still going to offer the buyer side compensation?
Yeah, it's a great question, and I'm not quite sure on how to answer that. There is a disclosure that's required on if you have an existing listing. I think CARs has a form that does this. I don't know the number on it. I don't know I don't know what's titled, but you need to disclose to your client that it's no longer in the MLS. That's all you need to do. The rest of the form is still intact, but you need to have a formal disclosure to the client that cooperative compensation has been removed from the MLS, is no longer listed. And I don't care how
Would
you
you put that on like an addendum that just says,
I think
Mr.
so.
and Mrs. Seller, you're aware that the compensation's been removed from the MLS, and they sign it and we're good?
Yeah,
Okay, perfect.
I think so. I think that's how I'd handle it, to keep it simple.
Thank you.
Rod, I have a question.
Yes.
Okay, where's that form, the form that you prepared? Did you already send that out to us?
It was sent out about a week ago, but I sent it directly to corporate. So it didn't go out to everybody because I don't have everybody's email. So
Okay,
talk to corporate, and then we may modify it a little bit more before you get the final version. I'm not sure what they're going to do with it. I haven't
Okay.
had a discussion about it, but I did prepare you guys a specific form with Remax champions on it, so you don't have to do anything but fill in the blanks.
all right, so they'll
It's
just
one
get
page.
that to us.
It's going to look like this, by the way. This is all I have. I think your clients will sign this.
Okay, yeah, I think
That's
so.
simple. Or
And then,
if you want to, you can give them this 5-page one, and here it is.
no, we're good. I know.
How many people think your buyers that come in off the street are going to sign this? Page
I
1,
know.
page 2,
Yeah.
page 3, page 4, page 5, and final. How many buyers are going to sign that when you first meet them?
And then Rod,
Champions,
you
really
had,
quick. So I have a bunch of Rod's newsletters. If you want to go into the chat, I put a link in there. I'm gonna get with management to get the final form, and we will be sure to send that out today.
perfect.
That
Okay,
should be in your new package. That
okay.
is one that you guys should really use in
Mhm.
lieu of the BRBC, because my concern again is that if you present the BRBC to your client before you even know them, that you're going to miss an at-bat with them, and you're not even going to get the opportunity to build the relationship that leads to the deal.
Yeah. Okay, and another question. So how would I put compensation up to? So when I say to the seller, I don't want to lock the seller into any amount at the listing. I want to say it's negotiable. How do you put that on the offer? Because if the buyer's agent comes in and says they only want 2%, and I've told the seller that, you know, it's going to be 3, but they ask for 2,
Yeah.
I want to protect my seller and obviously and make the most money for
The
them.
way you do that is it's going to be actually on your modification of terms - listing agreement. And what you put is up to 3%. So he's authorized and instructed to offer up to 3% to the selling office. And that way
On the
you can
listing
negotiate.
agreement, where do I put that?
That would be on the modification of terms / listing agreement. It's going to be on the modification portion. So when
Okay.
we talked about the RLA before, I told you there was 3 parts where you can talk about cooperative compensation. One was
Yes.
paragraph 2K. I said, I don't like that. Then
Yeah,
you can use a form that CAR just created, which is MT-LA. That's where I would put that. I would put that language directly there. And my newsletter has some recommendations on language. You can
Okay.
modify that however you want, and your point's well taken. Up to 3% would be great language. That way it opens it up for you to negotiate it.
correct. Last question. On your,
But he's
all right,
gonna say-
real quick, on the SBPP, you're referring to paragraph 2 and 3 to fill out. There's nothing to fill. There's no checkbox or anything.
Yeah, they have new form in the, if you see the car form, there's no more that form, the one that you mentioned to us.
Yeah, it's revised 7/24.
I think it was revised already.
Oh, well, I mean, I have a revised one here that was sent to me yesterday, so I don't know. I guess we'll have to get to the bottom. Does 3G3 still exist on the RPA? Because
Yes,
does anybody have a brand new RPA?
yeah, the 3G3 is.
Okay, so you check that, and does it reference SPBB, or how does it say?
The SPB is different now.
What's that?
The SPBB is different form now. I think
There's
they revised it.
there's nothing to check. There's
Okay,
nothing that
so
you write in or check.
okay, well, that's news to me. So G3, 3G3, what does it say then on the new RPA?
3G3 is.
Rod, I
Yeah.
think they're confusing the form that you were talking about. He was actually talking about the RPA, not the SPB. So I think
No,
that's where
no,
the
no.
confusion is.
No. He was talking about the SPBP to do something on 2 and 3. There's
Yeah.
nothing to do on 2 and 3.
Okay, I'll have to, the one I have was revised, but I guess I have to get another revised one. 'Cause this
Okay.
one here was provided yesterday, but it's been revised again. What does it say? What is the new, can somebody send me it? Somebody send me the revised SPBB. I could use it.
Mhm.
Figure it out right now.
Once they're revised.
Okay, Rod, I wrote an offer. I represented a buyer, but I didn't do any other forms.
Okay, hold on a minute first. I want to make sure somebody here can send me a brand new SPBB right now.
I'm trying to send it to you right now. Let me
Okay,
download
great.
it and send it.
Okay, tell me when it's been sent, and I'll have my secretary.
Oh,
send
there
it.
you go. Someone just screen shared it.
Okay, good. Let's see what it says. So settlement buyer's representation regarding that. That's totally changed from the one I have. It's been changed 3 times since then. Let's
Okay.
see. Subject people wouldn't be low. So when seller agrees to pay buyer broker 2% of the purchase price and or that. Okay, it's been simplified, which is good. Maximum, let me see. Seller agrees to pay buyer's broker 2% of the purchase price. Maximum seller obligations to pay buyer's broker the lesser of. Okay, yeah, somebody send me that by email, but it looks like it's even simpler than we thought. So all the other information I told you regarding paragraph 2 and 3, you can delete because it looks like they realized how silly that was and they revised it. So just revise, it makes it a lot simpler. Just put the commission that you want the seller to pay in paragraph 1 is what it looks like it wants you to do. And then that ends the form, which is exactly the way it should have been. It wasn't, but it should have been that way.
Perfect.
That's the 3rd or 4th version I've seen this month of the form, by the way.
Probably not the last.
All of these are going to be revised because half of them don't make any sense. So again, please send me that form. Next question.
So I wrote up an offer yesterday with a buyer, but I didn't use any of these forms. When does this whole thing become in effect? There was no escrow.
It came into effect yesterday. So technically, I mean, theoretically, it's the 17th. Okay, let me kind of backtrack on that. Theoretically, it's the 17th because that's when cooperative compensation, all the rules come into play. However, they eliminated the field for cooperative compensation yesterday. So there was no more cooperative compensation yesterday. So it would have been better practice for you to use all 3 of those forms yesterday. That would have been better because at this point in time, I'm assuming you made the offer based upon what the MLS was offering the day before.
Correct.
Yeah. And so at this point, I would just leave your offer alone because there was a representation that was made in MLS the day that you started preparing the offer. So for example, Monday, your client said, I want to make an offer on the property. You confirmed what they were offering on MLS, and then you wrote the offer up and submitted on the day that the field was taken away. But you've already relied on the amount that was offered in MLS. So go ahead and leave it. But any future offers, now that there's no MLS any longer with a cooperative compensation field, has to have the Trilogy of documents. So everything from today forward, you really need that Trilogy. Your transaction is in a transition period, and the way you've described it, I'm not concerned about it.
I have a question. I submitted a few offers with the RPA, the SPBB, but not the BRBC. If I were to open escrow on any of those properties, would I still be entitled to that compensation?
Let me ask, were those offers prepared prior to yesterday?
Yes, one offer was prepared yesterday and the other one was prepared before yesterday.
Okay, so was the offer asking for the amount of compensation that was advertised in the MLS the day before?
Correct.
Yeah, that I would classify your 2 transactions also as transition transactions. So you would still be entitled to compensation, in my opinion, because you relied upon MLS representations of cooperative compensation that were online the day before.
Okay.
But everything from this point forward has to have all 3.
Okay. BRBC, that's all I missed. Okay,
Yes.
Thank you.
Yes.
Rod, when you do open house, do you need to bring the form?
That's a great question. I mean, they've created a whole bunch of new impediments for open houses. So really what they want you to do is they want you to have everybody sign an agency disclosure, right? So you can tell them whether you represent them or not. They want you to have a broker compensation agreement ready in case somebody wants to hire you. And then they want you to bring one of 2 of these other documents. There's 2 other documents they have, which are open house visitors, non-agency disclosures. So the answer to the question is all I would bring at this point in time, if I were doing open houses, would probably just be your sign-in and then probably the OHNI-SI form. That's probably all I would start with. And that would be the open house visitors non-agency disclosure. That's the only, I would not, they have another one, but I wouldn't use the other form. I'd use the one that's SI. And then technically, yeah. And then there's another form. I mean, just to keep out, since we're talking all these forms, I'm going to bring up another one. They have the BRBC, which we talked about, and I think we're pretty intimate with that and how that works with your offer. But there's another one that's called an LPBRC. I don't know if you know about the LPBRC, but it's a limited property representation. And it's one that if you brought it to an open house, it would allow you as an agent sitting on the open house to represent somebody that comes in for a maximum of 3 separate properties. So you may want to bring that form in blank and have it ready, because if you do have somebody that says, hey, I really need a house today, I'd love to see some other properties, and you say, great, do you have an agent? No, you don't. Would you like me to show them to you? Yes, I would. You can whip the LP BRC out, and that allows you to basically secure a commission for up to 3 properties and comply with Rule 9.1 at the same time. Okay.
Perfect.
So just an answer, agency disclosure, OHNA-NA-SI, and then I'd probably bring 1 or 2 LPBRCs. That's it. A little more complicated, but none of these are subject to fines that I can see. So if you were to violate any of these rules at an open house, any of these suggestions, none of them are on the fine list for CRMLS.
Should I put the address where I'm being hosting the open house, or where I'm gonna do the open house? Should I put the address? And
If your
that's
client wants you to represent them in showing that open house as well as a dual agent, yes, I would have that address in the document, and then any of the addresses that you see. The LP form, LP BRC, is good for up to 3 properties. And you can put 3 separate addresses there that you're showing.
got it. Thank you so much.
Yeah, you bet. Okay.
Hey, Rod, I have a question. That LPBRC form, I'm on car right now. I mean, I can't even find it.
Maybe they've already revoked it. I don't know, but I mean, it was there last week when I got this lecture together.
Okay.
I've got it right here. If you can find it, good. It's a good one to use. It wouldn't surprise me if they revoked it, because it makes a lot of sense to use it. So wouldn't be surprised if it was revoked by CAR, because it makes too much sense for the form for them to keep that form. But it's LPRBC, Limited Property Representation and Broker Compensation Agreement.
Thank you.
Okay, hopefully you find it. If somebody finds it, let me know. If they revoke that form, again, we're living in a mercurial world here. I mean, things are changing literally weekly, sometimes daily. Okay, any other questions? This, again, just if you keep it as simple as possible, that's going to be what benefits you the most in this scenario. I think at the end of the day, I think buyers and sellers are both going to understand the importance of keeping things the way they are. And I think that sellers are going to be easily understand the necessity for offering cooperative compensation. I think once we explain to them what happened and the importance of it, we'll be able to conduct business as usual. All we have are a few new forms, and they're going to be different. I guarantee you the ones we're talking about today are going to be different in a month. Okay.
Rod, can you stay a couple minutes behind? I direct messaged you the broker compensation agreement. I want to make sure that's the correct form before I send it out to the agents.
Yeah, is it a 1-page document?
It's 2 pages.
No, it's the wrong one. There's one that's 2 pages and there's one that's 1 page. So let me see. I don't have it here. So
Cool. That was a good class.
is this it? No, that's not it.
I direct message you on Zoom. So if you want to look at your messages on Zoom.
Yeah, I have no idea how to do that. That's way over my pay grade. So if you email it to me, I can see it, but without
Okay, perfect. I'll email you now.
I'll never be able to see it on Zoom. If I try to see it, I guarantee I'll disconnect something. But it should look like this one. It should look just like this one here.
Okay, I have that one, but I'm going to send you this one just to be sure.
Okay, yeah, send me the 1-page one for me to confirm, and then that's the one that we'll include in the package. Okay. So in closing argument here, the one thing I'm going to just bring back to your attention again is I can't stress enough the importance for you to have the broker compensation agreement signed prior to showing property. Okay, it's critical that you do that, because if you don't do that, remember, CRMLS rule provides for an automatic $2,500 fine. So I do want to make sure that before you show properties, you at least have this simple broker compensation agreement executed. Any other questions?
Yes, I have a question. So pretty much the form that you just talked about, it's not the one that it should replace the one that you wrote for us?
No, the one that I wrote is a preliminary form that you only use for showing properties when you meet a buyer.
Mm-hmm.
And that allows you to show properties and comply with CRMLS Rule 9.1. The only reason I created that form. And when you actually submit the offer, then you use BRBC, RPA, and SPBB, the newest one, whatever that one might be at the time.
Okay, and then this form that you're talking about, the compensation form, the
Yes,
one page that you're saying that is used when? Then?
the one-page broker compensation agreement would be used when you are introduced to a buyer for the first time, and you're going to show them a property, or you're going to provide them property information. If you're going to provide them property information, or you're going to show them a property, then you have to have some sort of a broker compensation agreement in your file. And this is what I suggest that you use, because it's one page. And I don't think you're going to have a hard time selling it when it's one page that says they don't owe you anything.
Thank you.
My pleasure. Okay, anything else?
Hey, Rod, Michael here. I have a quick question on you.
Sure.
Do we need to change anything on our current listing?
The only thing I'm aware of, and I thought CAR had created a form, but who knows if it still exists or not. But all you need to do is have something in your file, and you can do it by addendum as far as I'm concerned, that just advises your seller that cooperative compensation is no longer available on the MLS, just so they know there's been a change. Just for full disclosure. That's all you really need to do.
Okay, got you.
Otherwise, all the agreements stay in force in effect. There's no material change in.
Okay, I see.
Okay.
I also have a coming soon listing. So the starting date is going to be next week, but the seller signed a listing agreement last week.
Yes.
So do I need to have them to re-sign the listing agreement, or I could use that like the previous version?
You can use the existing listing agreement, as far as I'm concerned. Your coming soon is going to operate just like it was. I'm assuming you're going to have, well, you have 21 days before, and then it'll automatically become active anyways. But yeah, it should run exactly the same, except on the listing, I would again do a modification of listing. That's probably the best form to use, or addendum or modification. That just says that the MLS is no longer, cooperative compensation will no longer be available on MLS. Just so that's the only addendum I would do to your listing. And you can use either an addendum form or an modification of terms dash listing agreement, which would be MT-LA form to do that change.
Okay, thank you.
Okay, yeah, my pleasure. Okay. My opinion is that 6 months from now, there's going to be very little change, and we're going to forget about all this nonsense. My commentary is that I'm struggling to see value in MLS for agents in California any longer. I'm not sure why we're members. You don't need to be a realtor in order to sell real estate in California. They're making our jobs a little tough right now. They're making it more complex than it needs to be. So my opinion is, I think at some point we need to reconsider what that membership is doing for us, and maybe elect new board members and try to get these guys to help us out instead of just finding us.
I'm in total agreement with you.
Okay. Yeah. It's a consensus. Some of my largest brokers that I represent, we've had sit-down discussions about whether that's a good thing for us to even be members and what our clients get from it, whether if we divorced from the whole organization, if that would make any difference in our marketing of property. And they're really considering it. I've got 2 brokers that have in excess of 2,000 agents that are seriously considered divorcing from the entire scheme. But we'll see what happens 6 months from now. At the end of the day, for you guys right now, listing and selling properties can be easy if you follow my checklist. And that's what I suggest that we do, is keep it simple. And we'll address problems as they come up. Okay. Any other questions before I head out?
Thank you, Rob.
Okay.
Thank you.
This is the most current information I have. Thank you for providing me the updated SPBB. Now I have that. I have not seen that document before. I received it yesterday, this other one yesterday, but that one's now I have it.
Yeah, I mailed that, or emailed it to you. You should have it in your inbox.
I do it. It's received. Got it. Thank
okay,
you very
thanks.
much for that. All right. Anything else?
Yes, I do have a question.
Oh, sure. Go
So
ahead.
this is Cara again. So pretty much as we are speaking right now, and you have prepared the forms that they were used when you prepare this whole meeting. Now we have new forms. I'm assuming that in a few days, you might consider like advising something different. Should we worry about that, or
No,
we just
don't worry
continue
about
this-
anything in the future. I'll worry about that for you. But
And
all
you
I
will let
want
us
you to
know.
worry about is just doing the forms that are required that by law today, by the rules today. And just worry about that. Any changes that come up, once I learn of them, I'll prepare a response and then I'll talk to you guys again.
Okay, thank you so much.
Okay. By the
Thank
way,
you.
if any of you hear something new, you'll bring it to my attention. You know, I've got my sources, but you guys sometimes are in the know more than I am. I'm in the know quite a bit. But if you find something that you think I should know about, send it over to me. I'd appreciate it. I mean, that's how we all keep informed.
Thank you.
Okay.
Sure, we
Okay.
will.
Okay. Any other questions? Again, if you don't remember anything else from the lecture, keep it simple. That's my message. Keep it simple. If we keep it simple, we'll be able to do business as usual, just like we've done for the last 25 years. Okay. Anything else? Going once? Going twice? We're done.
All right. Thank you, Rod. We appreciate it. Thank you, champions.
My pleasure. I have a feeling I'm going to be back in a couple of weeks. For some reason, I get that feeling. Okay.
Yeah, I'll get with you with the schedule. I'm pretty sure it's gonna happen.
I'm pretty sure it is too. See you guys later.
Thank you, Rod.